Okay, it's about 6:31, and I'm going to go ahead and get started with our Week 2 lecture for criminal evidence, J325. So I'm going to go ahead and jump right into the assignments for the week. Just a reminder about the fact that there's a post in there about a career fair coming up, and there's a document in the announcement that you can check out if you're interested in checking out the job fair. It's going to be the 26th. Here's the announcement itself. Opening it up. Okay. And 26th of July, 6 p.m. Central Standard Time. And this gives this flyer, and it tells you the link right here, and tells you where to go to find the information about this. So you want to, if you're interested in this career fair, you can register by going to this link. Okay. So okay, I'm gonna take that out of there. Okay. Okay, so now I'm going to go through and look at the announcements here. Let's see, Eric, you can actually open up your mic. I think I got you set so that you can open up your mic. Let's see. Go back to this. Oh, okay. All right, now your mic is there. So that I have you muted, but I'm going to unmute you so that we can talk. Actually, I better mute you back because it's making a little cricket noise. So if you need to say anything, then I can unmute you or you can unmute yourself. But in the meantime, what I'm going to do is I'm going to go ahead and go over the assignment back to what I had here. So let's take a look at the announcement for this week. Overview of the criminal trial and chapters 2 and 3 of your text, practical criminal evidence, and then this assignment on trial. This is also the section that has to do with your discussion post. I did submit a question for you that you'll see for your reply post, since you did submit an initial post already. And then, so your discussion assignment is right to a speedy trial, but you get your information from this on trial section. And then your written assignment is your criminal evidence project, introduction, selection, and summarize a criminal trial. And I'm going to spend some time talking about that as well. Okay. So let's look at our course calendar. Okay, here we go. We're here with our lecture. Your reply post, your initial post was due last night, which you did. Your reply post is due by Saturday. And then your written assignment is due by Sunday. And it's 2 to 3 pages. And I'm more interested in your critical thinking. Make sure you have APA citations and references. But I'm going to go over that a little bit more in just a minute. So again, let's get into the assignment. Your discussion on trial is where you find that information, and that's in the Lessons tab. And then this is your project. Now, let me make sure that you understand the project. Now, you can finalize your high-profile trial. I think and it's 2 to 3 pages. I think you decided to use the O.J. Simpson case. And what I want you to do is to provide answers to these following questions in your paper. First, a summary of the trial, which involves who, what, when, and where. And then the final verdict. So, oops, I got to delete that. That's a student calling me in another class. I'll have to silence that. Bear with me a second here. Okay. So anyway, so summary of the trial. So who, what, when, where, and then the final verdict. That's the point. Now make sure you write it in narrative form, not outline form. Now you can put the captions at the top and then write the information, but make sure you have citations in the body which support the information that you include in your paper. The trial's jurisdiction, whether it's state or federal, and you know that. And then you elaborate on that. Don't just give me a little short answer on it. And then a brief portrait of the prosecution and the defense lawyers team. There's information out there about both of them, the prosecution team and the defense lawyers team. Nicknamed the defense lawyers team the Dream Team, the Dream Team. And you can find a lot of information out there about that. Make sure, again, you indicate the sources that you get this information. What did the pre-trial process look like? Such as before trial, there were hearings, motions, bail, etc. Number of motions that took place before that, and you'll be able to find that information, and that's available as well. What kind of motions were filed? Were there motion to suppress statements? Were there motion to suppress evidence? There was a lot of that in there. What kind of evidence? Those kind of things. And you can discuss whether bail was granted, and if not, why, and so forth and so on. And again, make sure that when you talk about these things, particularly bail, that you address the issues from a constitutional perspective, making sure that you make it clear about bail and the Constitution, the 8th Amendment, and the issue that goes with that. Then after the verdict, did the trial end? Were there appeals filed? If so, on what grounds? That's an easy one to answer, and I'm not going to comment on it. All of us almost know what happened there, but again, we're talking about the criminal trial. Now, with that, I want to point out something to you. I think I got it right here. I think I gave it to you, but let me make sure that I did. Then I'm going to open it up so you can ask me questions about that. Hold on a second. Yeah. In this, I gave you the rubric for the week 2 assignment, and this is what you're going to make sure. But when you, this is your little check sheet that you have, and this is for week 2, a high-profile trial using the phrase famous trial. You already decided that, so you don't really have to do that. then you may want your to post your initial ideas in the general course questions, but you've already kind of dealt with that issue, and so as a result, that's just something for yourself. But here's what I want to point out to you. Make sure to maximize your 30 points, that you have satisfied each of the criteria. And basically, like I said, you got the APA format, references and citations. You'll lose points if you don't have those. And then the other issues are things that we kind of indicated just a few minutes ago there. So that's the assignment for week number 2. I'm going to go ahead and open this up for a minute to you. Okay, Eric? Okay, can you hear me?
Yes, I can hear you.
Okay, I can hear you now too. Did that clarify or clear up the issues that you had or questions about that discussion? I mean, about the discussion about the project?
Yes. I think the only question I really had was I had trouble in finding that I can't really find any rules of evidence pertaining to his case. Well, I mean, online at least. I mean, I find some by state rules, because I mean, from what I know, he tried in Los Angeles, right?
But that's fine. That's fine. Because one of the things that I said in the open house, and I think I said this before, and you'll notice again, the federal rules of evidence, almost every jurisdiction has tailored their own state federal rules of evidence that are applicable. So, yes, that's what I want you to apply, yes.
The other thing is I just having a little trouble finding, because I mean, I found
if you don't find any, it's okay, because the assignment itself doesn't refer to the rules. It applies primarily to the issues that we had there.
Okay.
Okay. Now, for example, there's testimony that takes place in there that involves hearsay and stuff like that. And when you provide the answers, I know this very well. I don't know if I said this to you, but I think I did, that I actually covered this case. I didn't go to California. I covered it because it was televised, even with motions and everything, and I was able to, I had to do reports to 3 radio stations on it, so I'm very well versed in this. But that's not a concern. That's not an issue that I'm mainly concerned. I'm mainly looking for the points that are indicated in our rubric and in the materials that are in the chapter there.
Okay. Yeah, that makes a lot more sense to me now.
Well, because here's the deal. The whole course is entitled rules, criminal evidence. So in the fact that what you're going to be doing is you're going to be talking about certain things in your paper at a certain point about what evidence came up, what things were discovered. I just throw a biscuit to you, the infamous glove. You know what I'm talking about. And then there's some other issues involving shoes and chain of custody with Detective Van Adder and stuff like that. These are things that you'll be able to discover by the time you get further into the project. But at this point, just remember, we're only focusing on this part of it right now.
Okay.
You got that?
Yes. That helps me out.
Okay, good. Now let me close your mic again, because I want to go back to just a few more things. Okay, let me go back to chapter 2. Okay, so that's back to the point. So you see that and you have that rubric. You have that rubric that I gave you. And that rubric basically follows the same thing as this, okay? So that's what you're going to include. And like I said again, make sure that I always tell students, use the rubric as a checklist and say, okay, I got to satisfy this requirement to get these 5 points for this. So you can get your maximum of 30 points for this particular assignment. So now let's move into the lesson content. The lesson content is okay. Your reading, you know what that is. You know the discussion right toward speedy trial. And then we already discussed this. Now, let's go to the on-trial section here. This little thing, and I'm going to have you to, actually, I don't know how to do this without making sure that I don't, let's see. Okay, I'm just going to do this and then go back to it. I'm going to, okay, open up your mic, and then I'm going to go back to screen share because I want to do this little exercise. So anyway, this is the section that you use to prepare your discussion post. And then there's some questions that we're going to basically go through right now. And then you can submit by midnight of Friday night. Midnight of Saturday night, your discussion reply. So anyway, the question of who's on trial here, where's the evidence, what happens next? And so the issue here is who's on trial? Well, it's the defendant. We don't know his name. I don't know his name there. And you can see that if that's a defendant, I'm presuming it is, that the evidence in this particular point. Now, what generally have you discovered from your reading is the research, is the evidence in a trial? What generally? Just specific few things.
Well, I think we would have to go to the initial hearings.
Okay, but let's get specific. What kinds of evidence? So, what evidence would you be looking at this picture? What evidence would you say is being elicited here?
Just on the pictures, testimony.
Testimony. There we go. You hit it, bam, right on the head. The testimony. Testimony is one of the big forms of evidence, and then there's other kind of evidence, and these are items, we call it physical evidence, and then there's circumstantial evidence that kind of not infers that something is taking place. We don't know about that right here. But anyway, with evidence, then they say what happens next. Well, in this case here, usually what happens is the witness is questioned by whoever put him on. We don't know whether if it's a defendant, I'm believing that it's the defense who's initially putting that person on, because the prosecution can't put the person on because you can't testify before it's testify against yourself. So then that individual testifies, and then they're subject to cross-examination. But that's just a little bit of it. Now let's get into the nitty-gritty of it here by going through this. It says criminal trials can be complicated, but everyone involved in a criminal trial, criminal justice, as it relates to evidence, becomes familiar with the nuts and bolts. It's important to see where your roles fit in the trial process by understanding that you can perform your part at the highest level to ensure criminal trials move effectively toward pursuit of justice. Now let's get to a few of these things. Now, I am going to, let's see, I didn't have the little arrow thing here. Okay, I'm not going to do that. I can put it here. Okay, now, the reasonable grounds to make an accusation. Which of these is it?
Cause.
Okay, so we move that over there. Correct. The legal equivalent of pleading guilty to a crime, criminal offense, that can't later be used as an admission of guilt.
No contender.
Yeah. Do you know what that literally means? That's Latin. Do you know what it means?
I don't.
No contest.
Okay.
It literally means that. That's in Latin, no contendere. And then obtaining identifying data, photographs, fingerprints of the suspect is?
Booking.
Yeah. So you get your mug shot and all of that stuff. And then, of course, the last one, court's lawful authority over territory, subject matter is the jurisdiction that they have there. Okay, so moving right along. Some more. Testimony derived from sources other than personal knowledge, secondhand.
Hearsay?
Yes. Now, you should be aware, and you're going to learn this, that hearsay is not accepted generally because it's very unreliable. And it makes sense. That's like, I tell somebody, Eric told me such and such and such a thing. They say, well, no, that's hearsay. Eric is the best person to say it and not you to say it for Eric. And it makes sense, too, for a number of reasons, because you and I both know this, that if you tell me something and I tell somebody else something, am I going to tell them exactly what you said in most cases? Am I?
Unreliable?
No. I'm asking a question. I'm saying, as a general rule, if you tell me something and then I go tell somebody else what you told me, am I going to generally say it exactly as you said it or not? Yes, not. You know that game that you can play where you start out whispering something with the first person and it goes through 3 or 4 persons. By the time it comes to the last person, it's not even what it started out with. And so what happens is it diminishes as it's passed on. And so the unreliability of hearsay says that in criminal cases, particularly since we're dealing with criminal cases, should not be allowed because we're dealing with reasonable doubt as a standard. So hearsay is not. However, the federal rules of evidence and most state jurisdictions provide what we call exceptions to the hearsay rule. We're going to get into that a little bit more later. But I'll give you an example of a hearsay exception. One of them is called a dying declaration. Now, do you know how that works?
No.
Okay, here's a dying declaration. You walk up on me, and then you're the police, and I'm laying on the ground, and I say, Eric shot me. And so that testimony, and then I die. So I'm not available for trial. But the person that I told that to could testify to that because I'm not available. And the reason for that is it's deemed that, and think about what I'm getting ready to say, and it's really funny. We laugh about this. Being a pastor and a minister, I laugh about it. But it also fits in the law. It says that because when we are at the end of our lives, it's been demonstrated that you're going to tell the truth. You don't have any fear from the person because you're dying, okay? So that's why we call it a dying declaration. If you don't die, it's not going to be admissible because then you're still available. But it's deemed that that statement is admissible against you because of the fact that you say, oh, that's hearsay. It is. But the federal rules and many states have set up an exception to say we need to be able to have this kind of evidence, testimony admitted into evidence. Make sense?
Yes, I'm actually curious though. Is that so? You're saying some states, specifically some states that don't allow that?
No. I'm saying that most states have tailored their rules of evidence after the federal rules of evidence. I don't know because I haven't looked at any other states, but I would say probably all states. I don't know about I don't know about Louisiana. Louisiana operates under the Napoleonic Code. However, though, they pretty much follow the federal rules of evidence in terms of their implementation in the state. So I would, what state you're in? Are you in Minnesota?
Illinois.
Are you in Illinois? Oh, then you're here with me then. Okay, so now here, this will fit perfectly, and you're familiar with this. You're familiar with the Drew Peterson case, right?
Yes.
Yes. Okay, so here's what happened with the Drew Peterson case, is that the testimony of his wife who died was able to be used because she had told someone that if I am killed, Drew killed me because of the fact that I'm afraid of him, and Drew is violent and his tendencies. So as part of the case that came up, the testimony of, I think it was a priest, or it might have been a priest or a minister or an attorney, was allowed to be admitted into evidence as a dying declaration because it went to the truth that Drew Peterson was the killer. Mm-hmm. So in Illinois, we do have it. Oh, we have it here in Illinois. I can tell you, we have dying declaration. It's a big part of the case, and that's a big part of what, in addition to other reasons why Drew Peterson got convicted. So that's just one example. There are some others too as well. Illinois is a good state. We pattern our rules right after. It literally goes down, bam, 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 bam. Section 7 of the Federal Rules of Evidence and all those different rules that follow under 700 to, I'm drawing a blank on mine, but all the way down, we have them in Illinois. In other words, basically what we did, we copied the federal straight down.
Okay.
All right. So now the next question is here, the bodies of citizens who look at evidence presented by the government. Yeah. And you should know the grand jury is not the same thing as the jury because the grand jury is a tool of investigation. Therefore, the only parties that are represented there are the prosecutors and their witnesses. The defense attorneys and the defendant are not included in the grand jury. And so the grand jury kind of goes along with the preliminary hearing, which determines whether there's sufficient evidence to bind an individual over for trial. And so if the grand jury votes what we call a true bill, then an indictment or information is issued, and then the individual goes to arraignment. If there is no true bill granted by the grand jury, then the individual is set free. Okay?
Okay.
Right to have legal counsel present during questioning. You know that one.
Miranda?
Yes, absolutely. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. And in Miranda, Miranda takes place when a person is under arrest. And by the way, how do we know when a person is under arrest? I think you were in one of my, well, you might have been in my other class when I dealt with this. But I dealt with this.
I believe until there's beyond reasonable doubt.
No. Well, at what point do you have to Mirandize a person, and what point are they? What is it that is a key thing that you should consider in terms of Mirandizing a person?
I feel like I know this, but I don't remember off the top of my head.
Okay.
I want to say evidence, but
what?
I want to say evidence, but I'm not sure.
No. How about this? Do you have to say that you're under arrest?
No.
Okay. So now, what is it?
An action forward. I'm not sure.
Okay, all right, that's okay, I'll tell you. You can't go. You're not free to go. You remember that? If you're not free to go, you're under arrest. Even if you're under arrest. And then that question that takes place from that point, if a person says, can I go? They says no. Then they don't have to answer any more questions. And if they answer any more questions and they're not Mirandized after that, then that could be subject to a motion to suppress, and any statements there could be thrown out. And the purpose for Miranda is to protect that individual from testifying or providing evidence that could ultimately end up having them to become successfully prosecuted. All right.
Okay.
And then I think I shared with you. I know I shared with all my classes that I had the pleasure when I was in law school at Northwestern to have a professor by the name of Fred Inbow. Professor Inbow was the author, along with a guy named John Reed, of the techniques that were under attack in the Miranda versus Arizona case, and that the Supreme Court actually, in the footnotes of the case, criticized the techniques that Professor Inbow had indicated that law enforcement should use in terms of interrogating and questioning individuals. And he spent the rest of his life until he passed away saying that he was maligned by the Supreme Court, and every time a case came up involving Miranda rights or Miranda issues, he would submit what we call an amicus brief, which is a friend of the court brief on behalf of the national, I may not get the organization right, but it's some organization of prosecutors to persuade the court to reverse Miranda. And I was fortunate enough to have, firsthand information that most people wouldn't have, which was pretty cool, to know some history behind Miranda and what was the reason why Miranda came about in the first place, getting it straight from the horse's mouth. So that was cool. That was cool. So I always share that as well. So somebody else is joining the meeting. I don't know who that is that's joining the meeting because nobody else is supposed to be in here. But at any rate, whoever that is in here, that's one of the things about these sessions is that if a student comes in early, probably from my other one, but it's not until 8:30. But at any rate, it's no big deal. So the last one is a formal accusation of a crime by a legal body of citizens, and that's, of course, the indictment. And that was what I was talking about that comes about from the grand jury. Okay, discovery is when the prosecutor and defense disclose certain evidence to each other that they intend to introduce at trial. In some jurisdictions, it's called disclosure. Is that true or false?
Let's say true.
Yeah, true. Because discovery is when the prosecutor and the defense disclose evidence to each other that they intend to produce at trial. Each side is entitled to evidence. With such disclosure, the parties can prepare to test that evidence through cross-examination or expert testimony, ensuring that the trier of fact, which will be the judge or the jury, gets a chance to hear both sides. Did you see the movie My Cousin Vinny?
Yes.
Okay, in that movie, you will discover, if you remember, he did not know that he had the right to cross-examine the witnesses before court and to interview them and that. And if you remember, his girlfriend gave him this book and said, because the guy, the prosecutor, remember, agreed to give him his files. And he thought, he said, oh, good, I finessed him to give him his files. Well, no, the reason why he gave him his files, and that's what was pointed out in that movie, is that she called a disclosure, that it was required by the prosecution to give him those files. Otherwise, it could not be used in the trial itself. So that's an example. And it really happens. It's true. That's very real. I will tell you this, that for purposes of the Speedy Trial Act that is involved in the discussion post this week, one of the ways that that the Speedy Trial is and I'm kind of helping you out with the question I asked. I don't even really have a chance to look at it, but there's that.
I did answer it.
Oh, you answered it already? Okay, because I haven't had a chance to look at it. But anyway, the point of the matter is that the when the discovery process takes place, that usually slows down the time. Let's say, for example, if you have 120 days, or 90 days, or 60 days. I haven't heard of any 60, but I heard of 90 days. In Illinois, our jurisdiction is 120. And so with being those number of days, at least that's what it was when I retired. I haven't looked at it, but I'm pretty sure it's still 120. But the point of the matter is that somebody will say, well, wait a minute. The case went on a year before. And that's because there's this period of discovery, because when the parties are waiting on discovery, then somebody's going to ask for a continuance. If somebody asks for a continuance, it tolls or stops the clock from running. And then when they get ready for trial, then it starts running again. So basically, the 120 days or the Speedy Trial Act can be sped up by, I've seen attorneys do something really stupid, and I saw one really, he really had egg on his face. He didn't even ask for discovery. He just demanded trial right at the beginning, which was dumb. Well, he didn't count on the prosecution coming forth with a key witness. And sure enough, just at the end, when it got to near the 118th day, and it was set for trial, that witness walked in. He messed up, and the client was convicted. But anyway, that's one thing. Now, the other thing that causes speedy trials to toll or stop is the filing of motions. The various motions that you go through for discovery, that's only one of the motions. Motion to suppress statements or written documents or any physical evidence, things of that nature. Evidence to determine the fitness of the individual to stand trial, whether it's insanity or diminished capacity, all those different things. And there's a whole list of them, and I talk about them in another class that keeps the case going longer. But the bottom line is this, is that to get to discovery and get it completed as quickly as possible so that the trial can take place, whether the person is in custody or out of custody, but especially if the person is in custody. Okay, double jeopardy allows courts to try an offender twice for the same crime as long as a year has passed. Is that true or false?
That's false.
Absolutely false. It is absolutely false. The Constitution in the Fifth Amendment prevents a defendant from being tried twice for the same offense, regardless if the verdict was conviction or acquittal. There was a really good movie, and the name of the movie was Double Jeopardy with Ashley Judd in it. Did you ever see that movie? Oh, you got to see it. It's available. In this movie, she is charged with killing her husband, and she goes to jail. She's serving time, and then she gets out on parole, and she finds out that in reality, her husband's still alive. He took up another identity, and one of her best friends was his wife. That's pretty messed up. But anyway, he had relocated from where they were living and had located himself to New Orleans, and she found him down there. Long story short is that he ended up trying to kill her because of the fact that he had, committed insurance fraud and everything else, and it was illegal what he did, obviously. So she ended up defending herself and shot him, and he killed him. And so because of double jeopardy, there could not even be a trial because she had already suffered the jeopardy for his death, even when he was alive. And that's that kind of thing. So now, one thing that people don't know is that there are people who are tried for the same offense twice. Do you know how that happens?
One for new evidence suffice.
Not really.
They acquire new evidence?
Nope. It's only one real way. It was used a lot in the civil rights cases when individuals were not convicted for lynching African Americans in the 60s and 50s, but years later, those individuals were tried, even though they had been acquitted by a jury, which really was a joke. So what happened is that they were charged on the federal charges and were tried on the federal charges and successfully convicted. So the answer to the question is that if you commit a crime, and for example, let's say an individual is charged with a crime, and that person is found not guilty of committing that crime, but that is discovered that that person operated under what we call color of law, or behind, for example, if you're a law enforcement police officer or either a public official, then they are tried by the Department of Justice on the federal level, then they can be convicted then, and that's not double jeopardy. That's not double jeopardy. Those are the rare times that those things happen. But no, the new evidence thing, no, they already been tried. That's it, and you get one bite of the apple. Okay. The next one is a legal term that refers to the time after an offender's conviction when the court makes a disposition expressed in a penalty. The time after the person is convicted when the court expresses
parole.
When the court makes a disposition. If you're found guilty, what does the court do next?
Distancing?
There we go. Yeah, that's it. Yeah. You see, you were looking at it. That's why you have to very carefully read. We're talking about if a person, after they've been convicted, then that position, then we would deal with parole. But right after they're convicted, before incarceration or any disposition at all, the next phase is sentencing. If there is no conviction, there's no sentence. So B is correct. Sentencing refers to as sentencing disposition is disposition by the court after defendant's conviction that is expressed as a penalty, such as a payment of a fine or a specified term in prison or probation, those kind of things. Parole doesn't come about until after you've actually served some of your time and then you're released earlier before that time is up. The Sixth Amendment guarantees a citizen's right to a trial, but not to a speedy trial. Is that true or false?
False.
That's right. That is right. Because that's you already know that from your discussion.
Yeah.
That's why this thing here is good. That's why they said use this to help you with your discussions and all of that. So the statement is half true, it says, but it actually is true. And here's the reason why I say that. And it says, but overall it's false. It says, in fact, the Sixth Amendment guarantees the right to a speedy trial. Reasons cited include minimizing incarceration prior to trial, minimizing loss of reputation for the accused, and or wanting to make sure the accused can defend himself or herself and not have to worry about the loss of evidence because of delays. But in reality, because of some things we've already talked about, many cases not begin within the time frame. Quite often, defense waives this right and uses delays as a tactic. That's what we were talking about earlier. So what it's saying is that, when they say it's half true, what they're saying is, yes, constitutionally it's correct, but it does guarantee a right to a speedy trial. However, though, the defendant, represented by the defense counsel, can delay time to prepare. So that's why it says that. So the answer is yes, true. It is, really is true. Okay, and that's the end of that. That is it. That's all I have. Any questions?
No, I believe you answered everything you wanted.
Okay. All right. Well, then you're good to go. And our next session will be 2 weeks from today at the same time. I will save this archive and I'll send it to you just so you can have it if you need it for a refresher sometime tonight.
Okay. Thank you.
All right. So I'm going to say good night to you.
Yes.
Okay. Bye-bye.